Welcome to episode 8 of the Zech Support Legal Studies series. It looks like our last episode did not get us canceled, which means the CRIM Law Chronicles continue. Today we will be discussing a topic that raises big questions about guilt, justice, and responsibility. This is accomplice liability. Imagine this. You and a friend are hanging out when they suddenly say, "Hey, let's stop by the store real quick." You have no idea they plan to rob the place. You wait in the car. Minutes later, they rush out with a gun in one hand and a bag of stolen money in the other. They tell you to drive. In your panic, you hit the gas and speed away. Here's the big question. Are you just a scared friend in the wrong place at the wrong time? Or are you just as guilty of robbery as they are? Welcome to the legal gray area of accomplice liability, where what you know, what you intend, and what you can do change your entire future. Today, we'll explore what it actually means to be an accomplice, the difference between mere presence and actual guilt, the legal requirements for proving accomplice liability, real-life cases where courts had to decide innocent bystander or criminal accomplice. So what is accomplice liability? Let's start with the basics. In criminal law, there are two main ways someone can be guilty of a crime. Number one, be the actual perpetrator. That means you commit the crime yourself. Number two, you aid and abet someone else in committing the crime. Even if you don't commit the act yourself, you help in some way. Now here's where it gets tricky. Let's say you drive the getaway car in a bank robbery. You never step foot inside, but under the law, you are just as guilty of bank robbery as the person who held the gun to the teller's head, proving accomplice liability. For a prosecutor to convict someone as an accomplice, they must prove four things. 1. The crime was committed or attempted. That means a real crime has to have happened. 2. The accused knew the crime was going to happen. There was foreknowledge of the criminal intent. 3. The accused intended to help. They actively wanted to aid the crime. 4. The accused actions or words actually helped. Even small contributions would count. It's not enough for someone to just be present at the crime scene. They must have actively assisted or encouraged the crime. So what doesn't count as accomplice liability? There's a huge difference between being at the scene of the crime and being legally responsible for it. For example, the wrong place, wrong time defense. Imagine you're standing outside a convenience store when a friend goes inside and suddenly robs the place. They run out, but you don't react quickly. Police arrive and arrest you both. You're not guilty because you didn't know what was happening, nor did you intend to help. The fear factor. A group of robbers storm into a bank and point their guns at the customer. They shout, "Everyone stay where you are, or we'll shoot." Terrified, you comply. You don't try to stop them. You would not be guilty of aiding and abetting. There's no legal duty to stop a crime in progress. Mere presence is not enough. So when does someone cross the line into criminal liability? Courts define aiding and abetting with 3 elements. You're going to hear some terms that you've heard in previous episodes. Actus reus, the criminal act itself. Someone else committed the crime. Mens rea, the guilty intent. The accomplice had knowledge of the crime and intended to help. Causal contribution. This is a new one. The accomplice actually contributed to making the crime happen. A classic example is a bank robbery. The robber with the gun is the direct perpetrator. The getaway driver outside the bank is an accomplice. The getaway driver outside the bank is an accomplice. The lookout on the street corner, also guilty. They helped by watching for the police. Let's use a case as an example. People v. Thompson, 2010. In this case, the California Supreme Court ruled that there isn't always a clear line between a perpetrator and an accomplice. Imagine 2 people plan to kill someone. Person A lured the victim into the alley. Person B pulls the trigger. Even though only one person fired the gun, the law treats both as murderers. Why? Because person A directly helped in making the crime happen. How to escape accomplice liability? Believe it or not, the law allows people to back out of crimes, but only if they act fast. To legally withdraw, you must tell everyone involved that you're out before the crime happens and make an effort to stop the crime. You agree to help in a robbery, but change your mind. You tell your friends, "I'm out," and warn the victim or call 911. You are no longer an accomplice. But if you wait until after the crime happens, it's too late. If you help commit a crime even in a small way, you are just as guilty as the perpetrator. Mere presence isn't enough. You must actively assist to be an accomplice. Intent is key. You must want to help for accomplice liability to apply. You can withdraw from a crime, but only before it happens. Can you be more guilty than the killer? Imagine this. A crime is committed. The person who pulled the trigger walks away with a lesser sentence while someone who merely assisted is convicted of first-degree murder. Sounds unfair, right? But here's the legal conundrum. Intent matters. Culpability matters. And in some cases, an accomplice's mind can be darker than the hands that actually committed the crime. Let's take a look at the McCoy case, when an accomplice bears more guilt. We're going back to 1995, to Stockton, California. It's nighttime. A drive-by shooting unfolds. A car slows down, gunfire erupts, and chaos ensues. When the dust settles, two men, McCoy and Leahy, are arrested. Now here's the twist. McCoy, the man who pulled the trigger and killed the man, claimed self-defense. Leahy, who was in the car shooting as well but didn't fire the fatal shot, is convicted as an accomplice. At trial, McCoy testifies. He admits to shooting, but says he thought someone was firing at him first. This, legally speaking, is called imperfect self-defense, a belief that you need to kill to protect yourself, even if it's not objectively reasonable. This matters because under California law, if the jury accepted this argument, McCoy wouldn't be guilty of murder. Instead, his crime would be voluntary manslaughter, a less severe charge. But what about Leahy? The Court of Appeals ruled that if McCoy's crime was reduced, Leahy's crime must also be reduced, because logically, an accomplice can't be guiltier than the actual perpetrator, right? Wrong. The California Supreme Court disagreed, and here's why. The legal principle. The court ruled that an accomplice's culpability is judged separately from the actual perpetrator's. Translation? If Leahy had a darker state of mind, if he intended to kill, then he could still be convicted of murder, even if McCoy was not. This set a huge precedent. The case law before McCoy stated that traditionally, the justice system assumed an accomplice could only be convicted of the same crime as the principal offender. But this ruling shattered that assumption. It established a new rule. If an accomplice's mental state is more culpable than the actual perpetrator, they can be guilty of a more serious offense. Why does this matter? Imagine a mob boss orders a hit. The hitman pulls the trigger, but because of a legal technicality, he's convicted of manslaughter instead of murder. Should the mob boss get off easy? No, because his intent was deliberate, calculated, and malicious. McCoy set the precedent that guilt isn't just about who pulled the trigger, it's about who had the darkest mind. So when does accomplice liability end? At what point does an accomplice stop being responsible? Over the years, courts have refined these principles. Furthermore, felony murder laws were revised to limit when an accomplice can be held responsible for a killing. Under California law, an accomplice is guilty of felony murder only if they were a major participant and acted with reckless indifference to human life. That's a much higher bar to clear than before. Reckless indifference is not just about being near the crime. It's about the choices made before, during, and after the crime. Courts consider factors such as whether the accomplice knew weapons would be used, whether they had the power to prevent violence, and whether they showed any concern for the victims afterwards. The case of Isaac Lopez is a horrifying look at how fear, manipulation, and psychological dependency can push a parent into dangerous levels of inaction. Isaac's mother, despite witnessing repeated violence, chose to remain with his abuser, and that choice cost Isaac his life. On April 20th, 2003, Lopez threw his 1-year-old son, Isaac, against a wall. His mother, standing just a few feet away, did not intervene. She saw, she heard, she knew, but she did not act. Isaac suffered 24 blunt force injuries before he died. Some from being thrown, others from being beaten. His lungs were filled with blood, a sign of suffocation. His stomach contained lethal amounts of pseudoephedrine, a cold medicine overdose, administered deliberately. And so, she obeyed. She stayed silent and later that night, when Isaac had stopped breathing, Lopez took his body and burned it in a bucket. His mother stood outside the bathroom. The legal question is, does failure to act equate to complicity in a crime? The answer, according to California law, is a resounding yes. So what about fear? What about abusive relationships? Can fear mitigate responsibility? The courts ruled that while these factors may explain behavior, they don't excuse it. A child's right to protection outweighs a parent's fear of reprisal. The penal code is clear. If you have a legal duty to prevent a crime and you fail to do so, you are complicit. The law doesn't require you to like the crime. It doesn't require you to benefit from it. It only requires that you allowed it to happen. If you see something happen and you suspect abuse, but you aren't sure, should you be legally responsible? Should a mother who fears for her own life be held to the same standard as someone who actively encourages abuse? And if silence is complicity, where does your responsibility begin? While some of the answers to these questions are clear, this isn't always the case. And that's why, like everything, the laws continue to evolve. What we do know is this: the law doesn't just punish actions, it punishes intentions. It holds people accountable not just for what they do, but for what they choose to ignore, enable, or encourage. Accomplice liability isn't just about being in the wrong place at the wrong time. It's about the choices you make before, during, and after a crime. And sometimes those choices can change your entire future. That's it for today's episode. If you haven't already, please remember to like and subscribe. Leave us comments, leave a review. Share this episode with anyone who loves diving into the complexities of the law. Until next time, stay informed, stay aware, stay on the right side of the law, and remember, when you need help, you can always count on Zech's support.